I appreciate everyone being here. Members, Madam Clerk, if you'd allow for the members to punch in, open the board. Members.
Oh, man.
We take a sip if you have one of those.
Kelly.
Madam Clerk, if you take the roll, please.
Mr. Chair, you have 19 members present. You have a quorum.
Very good. Members, before we get started, anybody have any announcements or personal orders or anything like to get out of the way? All right, we have a couple housekeeping issues here. So item 15, House Bill 2065 by Chairman Todd is going to be rolled for 2 weeks without objection. And also House Bill, item 23, House Bill 1971, that I'm sponsoring is going to be rolled for 3 weeks without objection. And with that, we're going to go just a little bit out of order without objection. Members, to item number 10 by House Bill 1766 by Representative Clements. So you have a motion in a second. And do you have an amendment traveling with this?
I do not,
You
Mr.
do
Chairman.
not. So you are properly recognized.
Thank you very much for taking me out of order. I appreciate it. This bill simply requires a fiduciary to state the date of the fiduciary's last contact with their conservatee on the annual accounting that they file with the court that supervises the conservatorship.
Very good. And thank you for that explanation. Members, do we have any questions for Representative Clements? Seeing none. Any objection to the question? All right, seeing none. Members, all those in favor of sending House Bill 1766 to calendar and rules, vote aye. Madam Clerk, you open the board. And all those opposed, vote no. As every member voted, any member would like to change their vote? Okay. Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 1 no, and 0 present not voting.
Very good. With that, congratulations. House Bill 1766 will be moving to calendar and rules.
Thank you, Mr. Chairman.
Very good. Members, if we could move to item 5. That's House Bill 1951 by Chairman Williams. Okay. We're gonna back up here. Without objection, we're gonna vacate that motion and second. And if we could, let's move to item number 16, House Bill 1765 by Chair Lady Littleton.
Second.
Chair Lady, you have a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. This bill, as amended, it does have an amendment on it, but I think is it traveling with the bill?
No, we need to add that. Members, we have an amendment coded 012700.
That's correct.
We'll go ahead and adopt that. You've got a motion and a second. Members, we're going to go ahead and put that on.
Please.
Okay, without objection, all those in favor say aye.
Aye.
Opposed, say no. Ayes have it. All right, we're back on the bill as amended. Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. This bill, as amended, enhances from a Class A misdemeanor to a Class E felony to the penalty for knowingly violating a lifetime order of protection when the conviction on which the lifetime order of protection was due to an offense involving the use of force against a victim. And I think, we all know that we have a person that works here that this has happened to. And once the guy was convicted, he was still sending letters to her from prison. And so when he returns, when he's released, we want to make sure that he doesn't do that. And I also have a witness, if we could call up, please.
And we do have a witness signed up to speak. Members, do we want to go ahead and go out of session, or we want to take questions? Okay, let's go out of session without objection. We'll hear from Ms. Waldrop. Penny, ma'am. If you would just come up to the table there and you can pick any seat you'd like. You'll have 3 minutes to give any statements you'd like to make, and then we'll have questions. We'll entertain questions from the members. And it looks like your red light's on there and your microphone. So if you just pull it down to where you can speak to it, and you'll have 3 minutes. So if you would just go ahead and introduce yourself.
Thank you. Hi, my name is Penny Waldrop. Chairman and members of the committee, thank you for allowing me to speak today. My name is Penny Waldrop, and I'm here not only as a survivor of extreme violence, but as a mother, a citizen, and a victim who continues to live with the scars of a horrific violent crime every single day. I survived an extraordinary, brutal, and life-altering attack that occurred in 2006. By every medical and factual account, I should not have survived. My attacker is my ex-husband. In front of me and in front of my children, he murdered my best friend, Leslie Bradshaw. As I tried to escape, he shot me multiple times. He then attempted to slit my throat with a knife, cut in my face and my ear. He repeatedly slashed me with a machete. After all of that, he attempted to rape me while I was bleeding to death. His ultimate intent was to kill me. The physical scars from that day are permanent and visible. The emotional trauma is even deeper. The violence happened in front of my children who will carry the memory of that day for the rest of their lives. I'm only here today because a worried friend repeatedly dialed 911, prompting a welfare check by law enforcement. Police arrived just in time for me to escape and for my attacker to be arrested. Without that intervention, I would not be here before you today. Because of the severity of this crime, I was granted a lifetime order of protection against my attacker. Despite this, he is scheduled to be released from prison in May of this year. And that is really terrifying. Under current law, if he violates my lifetime order of protection, which I believe he is likely to do, he would face only a misdemeanor charge. I believe this is dangerously inadequate. Someone capable of this level of violence has already demonstrated complete disregard for human life, the law, and the court's orders. A violation of lifetime order of protection should treat as the serious threat that it is and charged as a Class C felony. Victims like me have already endured unimaginable violence. We should not be forced to live in constant fear that the system designed to protect us will fail us again. Laws must reflect the reality of the danger posed by proven violent offenders, not only to victims, but to society as a whole. This is not about punishment for punishment's sake. This is about prevention, accountability, and safety. It is about ensuring that people who have demonstrated extreme violence are held to a standard that protects victims and the public. I ask that you please vote yes today. I ask that you please talk with those members who you know personally, who are on the Finance Committee, about the importance of this legislation and the need to fund in this. Thank you for listening to me and for taking this issue seriously. For all survivors, our lives depend on it. Thank you.
And thank you for your testimony. If you'll just stay right there. Members, do we have any questions or comments for our guest? Leader Lambert, you recognize.
Thank you, Mr. Chairman. And ma'am, you're a very brave lady. Your words matter to us. What you've gone through is unimaginable for anybody else to even possibly fathom. We support this bill. I hope everybody here will vote in favor of it. Yes, it increases penalties. It increases penalties appropriately on folks that need to be held accountable for putting you and so many others through the hell that they have. So I sure support it here and in the Finance Committee. But whatever the cost on a bill like this, it's worth it times 10 to make sure fewer folks like yourself ever have to suffer through something like this. And that's why we created the lifetime order protection. You shouldn't have to go back down to court year after year after year and face this person. And if they violate it, it ought to have some serious penalties. So thank you for your testimony today. We deeply appreciate it and understand that we hear you.
Thank you so much.
Members, anyone else? I'm sorry, Representative Johnson, you're recognized, and then I'll get to you, Salinas.
Thank you so much for your courage. And I heard about your story before you told it, and I appreciate you coming forward and talking about it. I know it's not easy. And typically I'm not one for enhancements, but I think that it's very important. And my hope for you is just that you can feel that safety that you deserve. I just hope that for you.
Very good. Representative Salinas.
Yeah, I just want to echo Representative Johnson's comments to you. Thank you for demonstrating so much courage and coming up in front of us. I know it's not easy to relive a lot of the trauma that happened to you, but I think your courage is so admirable. And I know many people are going to be safer because of the courage that you exemplified today.
Thank you.
Members, anyone else? Representative Towns?
Mr. Chairman, thank you, and thank you as well. Unfortunately, in this world, there are people that want to control people by force, whether it's a domestic situation or otherwise. And as it is in the domestic situation, obviously it's very volatile, very dangerous. And many men, I think, believe that that makes them strong, but they're weak, a bunch of punks, and they do it and they get away with it. And as I've said in this committee before, there's some people's sisters, mothers, or friend girls you can't do it to because they have brothers. What brothers do is come and get some of that hind part. So thank you for the bill, and hopefully this will go around the state to make sure men know there are really dire consequences for hurting people, abusing people, killing people. People get killed. It's serious business, and they have to be stopped. A bunch of punks have to be stopped at all times. So thank you for the bill. Mr. Chairman, thank you.
Thanks, sir. Members, anyone else? All right, seeing none, are we ready to go back into session? All right, without objection. Thank you for being here. Members, do we have any questions for the sponsor? Any objection to the question? All right, seeing none, looks like we're ready to vote. Madam Clerk, if you'd open the board. Members, all those in favor of sending House Bill 1765 as amended to Finance, Ways, and Means, vote aye. Those opposed, vote no. Those ever member voted? Any member like to change the vote? All right. Madam Clerk, you take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. With that, House Bill 1765 is moving to Finance, Ways, and Means. Okay, members, without objection, we're going to move to item 4. That's House Bill 1933 by Chairman Vaughn. Mr. Chairman, you have a motion and a second, and you're probably recognizing I'm not looking at any amendments here, so.
No, sir. Thank you for that, Mr. Chairman, and hopefully I'll get a similar round of applause for this really earth-shattering piece of legislation. No, just a heart-wrenching story to hear. This one is not heart-wrenching. This is requesting a TASER study on behalf of the Shelby County District Attorney's Office to look at pay disparities between county hired prosecutors and state hired prosecutors operating within the same office. And that is the extent of what this bill does.
Thank you for the explanation, Chairman Vaughn. Members, do we have any questions on this bill? Representative Towns, you're recognized.
Mr. Chairman, thank you for the bill as well. So if we find a disparity, are we going to correct it? Because I think that they're from, conversations I've had in the past, and it's pretty significant too.
Chairman Vaughn.
Thank you, Mr. Chairman. Well, that'll be for this body to decide. Representative, I know in finance during the budget hearings, we've heard from both the Public Defender's Office as well as the ADAs that they have performed their own weighted caseload study over the last few months. And so what this will do is not only look at just the Shelby County office, we know that disparity occurs there, but it'll also look at how prevalent this issue is across the state. And so that we can figure out what type of commitment it would take for us to balance that out, or what the best tactic would be to deploy to figure out how to make sure that we have the most people handling people's cases throughout the state.
Very good. Representative Towns, any additional questions?
Yeah, I think you're right. Love to sign on to the bill. But from this previous testimony in the past, it was so egregious that some of the people that were working for us, they could not pay back their state loans. They're not state loans, but their college loans. They were really, really working on thin margins. And that's really upsetting to have a job of that level, of that caliber, and you barely making a living. Tennessee got to step up and pay people for what they do the right way. We need to pay our people, okay? They have to be paid adequately and competitively. I would like to see also what is happening in the general region, Atlanta and some of these other places, but we got to pay our people. So I'd love to sign on to the bill.
Thanks, sir.
Very good. Members, any additional questions? Representative Salinas, you're recognized.
Yeah, I know this came up in front of the county commission trying to get parity So I do appreciate the study. I voted for it and I will continue to vote for it. But I think this would help our counties plan better their budgets and be more consistent and not have to address some of these needs in a meeting or two. So yeah, thank you.
Very good. Chairman Vaughn. All right, members, any additional questions? All right, seeing none. Any objection to the question? All right, looks like we're ready to vote. I'm sorry, what? Oh, if I would withdraw that. Representative Hardaway, did you have I didn't see you down there, sir.
Thank you, Chairman. Good afternoon, Chairman. I may have missed it, but what's the relationship between this bill, the study for the assistant DAs and the public defenders?
Chairman Vaughn, you recognize.
Mr. Chairman, there isn't a relationship there. I was just saying, I was bringing up the fact that both those offices have performed their own weighted caseload study with regards to staffing needs. This would bring an outside group to take a look. I'm sure that is also a part of a pay study, or you would think that it would be. And so this brings the expertise of TASER to bear on all the issues dealing with the blended labor force within an ADA's office.
Okay, may I suggest that you make that clear? I've seen at times where individuals fail to understand that if we don't have that balance, that we end up with gridlock. If we don't have enough public defenders to deal with the DA's work.
Chairman Vaughn.
Thank you, sir. That is not what the Shelby County District Attorney requested of me. I'll look and see if this caption may hold a later amendment, but I sure would like to keep this train on the tracks as it stands. And that sounds like that would be a great bill for someone else to offer if they have a caption that can handle it.
So, Mr. Chairman, let's vote on this bill.
Very good. All right, members, looks like the question's been called. Any objection? All right, seeing none, all those in favor of sending House Bill 1933 to Finance, Ways and Means, vote aye. All those opposed, vote no. Has every member voted? Any member want to change their vote? And okay, all right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 21 ayes and 0 noes.
Very good, members. And Mr. Chairman, House Bill 1933 is moving to Finance, Ways and Means.
Thank you, Mr. Chairman and committee. Appreciate it.
All right. With that said, I saw Chairman Williams arrive, sir. And we're going to take, members, without objection, we'll take item 5, House Bill 1951. Sir, you have a motion and second.
Thank you.
And looks like we have an amendment 013175 traveling with us. Does this need to go on?
Yes, sir.
All right, members, we're going to go ahead and adopt this. Looks like we do. We have a motion and a second. Any objection? Seeing none, all those in favor of adopting House Amendment 13175 to House Bill 1951, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you are properly recognized.
Thank you, Chairman and members. This bill was emanated from someone in my district who, unfortunately, their daughter fell victim to coercive suicide using a social media platform over many years of discussion. This bill would, in the assisted statute portion of the code, add coercive suicide and create a Class D felony. With that, I'm staying ready to answer any questions. Chairman, I don't know if the family's here to speak today or not, but happy for them to do. Oh, there you go.
Yeah, I have Chairman Williams, and members, I have Miss Candy Sparks and Hannah Duncan on the list to testify. So would we like to go out of session here for them? Okay, very good. All right, without objection, we're out of session. All right, Miss Sparks and Miss Duncan. Ladies, if y'all just come up to the table there, have a seat wherever you'd like. And each of you will have 3 minutes to speak, and then we'll open it up to questions after that. Looks like both of your red lights are on your microphone. That means we can hear you and everyone else can. So we can just start with everyone start first. You can have 3 minutes to present your testimony. Just be sure to introduce yourself to the committee, please.
Chairman and members of the committee, thank you for allowing me to speak today. My name is Candy Sparks. I am the mother of Grace Ann Sparks, and I'm here in support of HB 1951. In 2019, my daughter, Grace Ann, died as the result of coercion. systematic psychological pressure, manipulation, and exploitation by someone who understood exactly how to push her towards harm while maintaining the appearance that her final act was, quote unquote, her choice. It was not, it was engineered. I want to be clear at the outset. This bill is not about criminalizing speech, grief, or difficult conversations. It is about conduct. Specifically, it addresses the intentional encouragement of suicide when a person has already expressed suicidal intent and is known to be vulnerable and at imminent risk. The legislation is not about criminalizing grief or mental illness. It is about accountability for predators who exploit vulnerability and hide behind technical gaps in the statute. It is about deterrence. It is about truth. Under current law, if someone repeatedly pressures, manipulates, or encourages another person towards suicide, but does so through messages, calls, or online platforms, there is often no clear statute that applies unless that person is physically present or directly assists in the act. That gap is not theoretical, it is real, and it has consequences because technology has changed. Harm occurs because technology has changed. The law has not kept pace. Coercion does not become less powerful because it happens remotely. Psychological pressure does not lose its effect because it is delivered through a screen. When the outcome's the same, accountability should not depend on geography or proximity. As a mother, I will always carry the weight of what happened to my child. But I'm not here today asking this committee to legislate grief. I am asking you to legislate responsibility. This bill provides clarity where there is currently ambiguity. It closes a loophole that allows individuals to knowingly exploit another person's mental health crisis without consequence, and it creates a clear deterrent by drawing a firm line between protected speech and intentional harmful conduct. If HB 1951 had existed when my daughter was alive, her case would have been understood sooner and prosecuted more clearly. Her abuser, and ultimately her killer, would still be in prison. Families like mine would not have had to fight so hard to have coercion recognized for what it is. I respectfully urge this committee to pass this bill, not out of emotion, but out of responsibility. Responsibility to protect vulnerable Tennesseans and to ensure our laws reflect the reality of how harm occurs today. Thank you for your time and consideration.
And thank you for testimony.
Chairman and members of the committee, thank you for allowing me to speak today. My name is Hannah Duncan. I am Grace Ann's sister. I am also a mother to 2 young daughters. Raising them in a world where predators no longer need physical proximity to cause harm. They can reach a child or any vulnerable person through a screen at any time, anywhere. I am here today in support of this bill as a sister, a daughter, a mother, and a Tennessean. This legislation addresses a serious gap in our current law. As it stands, someone can knowingly and relentlessly encourage another person towards suicide through pressure, manipulation, and psychological control, and face no clear accountability unless they are physically present or directly assist in this act. That distinction no longer reflects our current reality. Technology has changed, and as my mother mentioned, our laws have not kept up. This bill is careful and limited. It does not criminalize speech. It does not punish conversation, grief, or misunderstanding. What it addresses is conduct, specifically the knowing encouragement of suicide when someone has already expressed suicidal intent and is in immediate danger. That is a critical difference. Right now, the law effectively suggests that coercion only matters if it occurs face-to-face. But coercion does not lose its power when it happens through messages, calls, or online platform. The emotional pressure is real, manipulation is real, and the consequences can be irreversible. As a mother, I think about the world my daughters are growing up in. I think about how easily vulnerable people can be isolated, targeted, and influenced without anyone else in the room with them. Laws exist to protect people when they are most at risk. This bill does that. Passing this legislation is not about one family or one tragedy. It is about acknowledging how harm occurs today and ensuring our legal system has the tools to respond when someone intentionally exploits another person's mental health crisis. I respectfully urge this committee to support this bill and help close a loophole that leaves vulnerable people unprotected. Thank you for your time and consideration.
And thank you. Members, do we have any questions for our guests? Any questions? I don't see any. Oh, Representative Towns, you're recognized.
Mr. Chairman, thank you. And thank you for your testimony. Unfortunately, what I want you to do, if you don't mind, just tell me a little bit about your child.
Grace Ann, about Grace Ann?
Mm-hmm.
She was a very kind spirit. She was very generous with her love and her ability to help other people. She adored cats and horses and would take in any stray cat, unfortunately. And she was smart, bright, pretty.
Very giving
Mm-hmm.
to a fault, unfortunately.
How old would she be today?
Today she'd be 26 years old.
Wow,
Actually, in March, she'd be 26.
really young.
She was 19 when this
She's
happened.
19.
Unfortunately, we live in a world, and I'll talk about our country, that I think one of the number one problems in our country is a bad heart. A lot of people, young and old, because they haven't been raised, got an evil heart. And they thrive on doing evil things. Unfortunately, they can be young. I mean, where does it come from? We've gotten off track somewhere. But we have a heart condition in this country. And thus you have to come to a body like this to try to create laws to deal with those conditions and those habits. What you're asking for is not really harsh enough. You know, you're not supposed to kick the weak. We were trained you don't do that. You're not supposed to, you know, really misuse the poor, the elderly. We're not supposed to do that. When I come along, we didn't do that like that. But today you see them doing that. Kids, all, you know, from all walks will do that. So we have to control their behavior as best we can. God gave you a great child. Unfortunately, the evil of the world took it away earlier. But I'm sure she's proud of you being here to fight to help somebody else's kid. Okay? So keep your chin up and live and love the memories that you had with her. Thank you for sharing as well. Mr. Chairman, that's it.
Thank you, sir. All right, members, anyone else? All right, Representative Powell, I'll have you. You're recognized.
Thank you. Appreciate your bravery being here again. I know I heard the story in subcommittee. I do know, unfortunately, our youth are all too subjected to hate, and for various reasons. They might be different. They might be in a community that might not support them. They might be dealing with their own personal mental health crisis. And, you know, that is becoming too prevalent. And really sorry what happened to your daughter. And know that we have to continue to protect all citizens, especially the children in our state, and show them love and appreciation and kindness. And so I'm proud to actually sign on to this bill. I know I've heard some people are, some issues that people have brought to my attention, but I think that we do unfortunately see too many people that try to prey upon others, and it's wrong, it's harmful, it's sinister. And so I appreciate your bravery, because you're right, technology does evolve. And so many of our children are now preyed upon, not by in person, but by this device here. And we have to protect those children as we see telecommunications, social media change, and other methods of communication. So thank you for your bravery, and hope we'll support this bill. Thank you.
Very good. Members, anyone else? Are we ready to go back into session? Any objection? All right. And we appreciate you ladies being here today. We're back in session. All right, back on the bill. House Bill 1951, Chairman Williams, as amended, you are recognized. 1 second, Ms. Johnson. All right, Chairman Williams, you're recognized, sir.
Thank you. She just wanted to add that if you wanted information regarding the case, it is a matter of public record. If you wanted to get that information, you can contact my office and we'd be happy to send you the information regarding that particular case, which was the impetus behind this bill.
Okay. All right, members, any questions for Chairman Williams? I have Representative Johnson. You're recognized.
Thank you, Mr. Chairman. And thank you for the legislation. I had a friend in college who, a former partner, I found out later, we didn't know this at the time, she committed suicide, found out later for certain reasons that he was calling her by phone from another state. And that is what, made this happen. He coerced her without question from those phone calls. And so I think it's really important, but someone else has also brought to my attention, and I don't know if there's anything we can do, but the possibility that in some relationships, people use, I'm going to commit suicide if you break up with me, that type of thing.
Mm-hmm.
And so say that they were saying this to you on a text message and you responded, you do you, or, just at some point, you've got to not let that influence things. So could this bill cause a problem in that sense? Is there any way there would be some language that could carve out something like that?
Chairman Williams, you're recognized.
Thank you. The language in paragraph 1 is pretty specific about that. The big challenge here, and in other states, this is not a problem that is new to the states. There are other attempts at trying to do the coercive suicide statute based upon not only the Sparks family's experience, but others across the nation. And in some states across the United States, the issue of free speech has called to question the coercive suicide statute. So along with their help and Office of Legal Services help, we were able to petition the Attorney General's office to help us narrowly craft this in such a way where we felt like it would be defensible if someone did that. As it relates to their particular case, it was a long, drawn-out, repetitive process which spanned more than 5 years, with a small break in between when her mental health was good. And so he would enter her world again through this social media platform and cause her to coerce her in this fashion. As it relates to that, I would argue that the big challenge would be this long, drawn out definition of what coercion would be. And in the instance of defining what coercion would be, I think it would not impact the situation which you just described. But that would be up for the court to decide and the district attorney as it relates to prosecutorial charges.
Representative Johnson.
Okay. Yeah, I get that. And I really did appreciate them talking about the First Amendment, because I don't see that issue, at all. It's just this situation where some people sadly in relationships do kind of use that as a tool. And so I appreciate that explanation.
Thank you.
Very good. Representative Towns.
Thank you, Mr. Chairman, again. Thank you for the bill as well. In the scenario that my colleague just referred to, what happens is that person who's not wanting to be or wants to still be in a relationship calls the other person, say, well, if you do this to me, I'm going to end my life. Now, the person that's trying to run away, they're not calling them. It's the reverse. They're not harassing them. It's the reverse. The person is not wanting to terminate the relationship is the one that's harassing them by calling and telling them, I'm going to commit suicide, which is some, since the battery may be real, may not be real. Now, me personally, if I thought that, if I was involved in a scenario like that, I just, I tell him that we're not going to get back together. However, I would report him to his mother or to some agency to go check his mental status out. That's just personally for me. But if I knew his mother, I would certainly tell his mother. If I knew his sister, somebody can, I'd certainly do that. Not that it's my responsibility, but I would do it. But they're using it to make you feel we can come back in a relationship. It could have been a battery relationship, but they're not pursuing them at all. They're not. They only talk to them when they call them. And of course, you block your number too. Thank you, Mr. Chairman.
Thank you. I'm sorry, did you have any response? Leader Lambert, I have you, sir.
Thank you. And members, from Section A1 of the bill, it has a mens rea of intent. So, I mean, you have to intentionally, in any manner, advise or encourage another person, and it continues from there. So, I mean, it is very clear that it can't just be an offhand remark. I will say to my friend from Knoxville, I hope that we will all continue to try to educate everybody in Tennessee that a bill like this exists, that there are people that are losing their lives and there are people that are losing their loved ones, sometimes over a text that may be dismissive of a genuine outreach for help, where that person may be communicating that they intend to commit suicide and they are begging for someone to say, please seek professional help, please get help, for everyone to take any threat of suicide seriously. That goes beyond this bill. That's more. But if you ever want to go to the Jason Foundation website and see some resources, it's a great organization that does suicide prevention throughout our state. And they can really, there's a good way to deal with that, but being dismissive of it, and I'm not saying my colleague in any way was advising that, but it's a good conversation to have back and forth. And I think for us all to make sure people understand, because that would be the hope, is that not only would we outlaw coercion, intentional coercion as this bill does, but we would also expand the knowledge for every Tennessean that if someone makes a threat, even if you don't think it's serious, take it serious. Get them some resources, get them some help, intervene. Thank you for the bill.
Thank you for those comments. Chairman Williams?
Thank you. I would just add, this is such an important topic, particularly suicide. This body, you have invested our state's resources in places like Jason Foundation because of the work they're doing in this space, and being leaders in our community. It's our role, it's our job to communicate with people about these kinds of things and remove this fear that might exist because someone is feeling or having thoughts of harming themselves.
Representative Hardaway, I saw your hand.
Thank you, Chairman. And I'm just going to offer a little short observation that suicide is a lot different, even though we're back in session. I'm still speaking to Grace Ann's family. To have the courage to come forward to even acknowledge it publicly is rare. And without those type of shared experiences being shared, then we're not making the progress that we could. So it's not merely the bill itself, but the fact that the family has chosen to fight this publicly and tell the story. Most of the other crimes of this nature where life is taken, folks talk about it. You see it on the news. You read it in the print. You see it online and read it. But it's rare to have family who are strong enough and are able to reason this out, that moving forward, they can make that child's life mean something to everybody else. And I applaud you for it. Thank you, Mr. Chairman.
Very good. And thank you. Chairman Williams, any comments?
No, sir.
Very good. Members, any additional questions? All right. Any objection to the question? All right. Seeing none. Looks like we're ready to vote. Send House Bill 1951 as amended to Finance, Ways and Means. Members, Madam Clerk, if you'd open the board. Members, all those in favor vote aye. Opposed, vote no. Is there a member voted? Any member will change their vote? All right. Madam Clerk, take the vote.
Mr. Chair, you have 22 ayes and 0 noes.
Very good. Congratulations, Chairman Williams and ladies. House Bill 1951 as amended is moving to Finance, Ways and Means. Very good. That brings us to item 6. Chairman Williams, you also have the next bill on the calendar, and we'll stick with you while we got you here. It's House Bill 2026, and you've got a motion and a second. I'm looking at House Amendment 13099. Is that something you'd like to go ahead and put on or talk about? Or
Yes, sir, I would. It simply just allows for an exemption for TDOT as it relates to the right-of-ways, any boundary stakes that they may need to remove.
Members just need got a motion and a second. You've heard the explanation. Anybody have any questions for the sponsor regarding to House Amendment 13175? All right, seeing none. All those in favor of adopting House Amendment, 13099. That's House Amendment 13099 to House Bill 2026. Say aye. Aye. Opposed, say no. Ayes have it. And now we're back on the bill as amended. Sir, you're probably recognized.
Thank you, Chairman and members. This bill simply makes it a misdemeanor, a Class A misdemeanor, if you remove. It was brought to me by the Tennessee Association of Land Surveyors. Unfortunately, in Tennessee, it's not a criminal offense for you to pull up your neighbor's or friend's pin or placement or boundary on property. And so in a lot of cases, in order to get that reset, you'd have to hire a surveyor to come back and reset those pins. This simply just makes that a misdemeanor. I would like to clarify, however, and thanks to the great work of our legal counsel, Ms. Fogarty, she reminded me this morning that Representative Powell asked me a question regarding wooden stakes. You asked me if removing a wooden stake would be okay as relates to Class A misdemeanor. Some wooden stakes do have the surveyor's pin on them. So if it were a pinned stake, then you could not remove it. But if it were a wooden stake that was not pinned by the surveyor's mark, you could in fact remove it.
Very good. Representative Powell, saw your hand. You're recognized.
So as you know, oftentimes surveyors will put the pin stakes, but then they also have additional stakes that just the property owner can see to more clearly mark the boundaries. So in that case, if it wasn't pinned, then it was just a wooden stake
That's correct.
that was used for that purpose, that would not apply to this. Is that correct?
That is correct.
Thank you.
Yeah, very good. Any additional questions? Representative Johnson?
Yeah, I'm trying to understand because I've got a lot of calls on this. But it's typically the wooden stakes that they have moved.
Chairman
Yes.
Williams?
In an instance, if you have a century farm, a lot of times they'll put a stake in the ground, they'll put a pin or marker in the ground, and sometimes trees grow up over that pin or marker. And if the deed describes it as the tree and not the pin over time, then the tree is actually the marker. That makes sense.
Okay.
President Johnson, any additional questions?
No,
Okay, thank you for that. Members, any additional questions for the sponsor? Any objections to the question? All right, seeing none, members are ready to vote. Send House Bill 2026 as amended to Finance, Ways and Means. Madam Clerk, if you open the board, members, all in favor, vote aye, opposed, vote no. Has there been a vote? Anybody like to change the vote? All right, Madam Clerk, you go ahead and take the vote.
Mr. Chair, you have 22 ayes and 0 noes.
Very good. Congratulations, sir. House Bill 2026 as amended is moving to Finance, Ways and Means.
Thank you, Chairman and members.
And if we could move back, to the top of the calendar, I saw Leader Cochran there. House Bill 2019, and I'm not seeing an amendment, sir, so it looks like you're ready to go.
That's correct, Mr. Chairman. Thank you. House Bill 2019 essentially allows the Attorney General to initiate proceedings to actually current code already gives the Attorney General the power to initiate proceedings to dissolve a nonprofit. So, but the current law has the venue restricted to just Davidson County. This law would give the Attorney General more flexibility on choosing a venue. Obviously, nonprofits are located across the state. He could choose a more convenient venue than Davidson County.
Members, you heard the explanation. Any questions? Representative Powell, you recognized.
Question. I was looking at the amendment. Is it anywhere in the state or is it limited to what counties it could actually be in?
Leader Cochran.
I believe that would be anywhere in the state.
Okay, now.
But there's no amendment, just for clarification.
Okay.
Very good.
All right.
Okay. Representative Towns.
Leader Cochran, thank you. Help me to understand what would be some rationale for the Attorney General wanting to dissolve a nonprofit. What do we have to make this bill necessary?
Leader, you recognize.
Sure. Thank you, Chairman. Thank you for the question. Obviously, we would hope that this would be a rare occurrence, but it happens from time to time. If a nonprofit is perhaps doing something that might be illegal or
Right.
breaking the law, or if they've just been a consistent bad actor. But yeah, that is already occurring. This speaks more to the venue where that would be selected to bring the case.
Okay.
President Towns.
Yeah. Now, that being the case, is there a procedure that if they still want to function, that they would have to go through to get their nonprofit reinstated? I'm thinking about this community stuff, people doing great stuff for children's science or what have you. Will they be prohibited from doing that? Is there a procedure that will have to occur for them to be reinstated?
Leader Cochran.
Thank you, Mr. Chairman. So, Representative, this bill does not speak to that process. I would imagine that process is in place. This one, though, is very specific just to giving the Attorney General flexibility to choose the venue for these proceedings.
President Towns.
Yeah. Thank you, Mr. Chairman. Thank you, Leader.
Thank you.
Very good, members. Any additional questions for the sponsor? I'm not seeing any objection to the question. All right, very good. So without objection, we'll be voting to send House Bill 2019 to calendar and rules. Madam Clerk, if you go ahead and open the board. Members, all those in favor, vote aye. Opposed, vote no. Every member voted. Anybody want to change the vote? All right, very good. Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. Leader Cochran, House Bill 2019 is moving to calendar and rules.
Thank you, Chairman and Committee.
Very good. And I saw Representative Hell, sir. Let's go ahead and you've been sitting there the entire time. We'll be able to get, probably after this bill. I'm sorry. Chair. Okay, that's fine. Go ahead. He just been sitting here the entire committee meeting. Let's go ahead and, Chairlady Kemper, you're recognized.
Thank you, Mr. Chair.
Very good. You got a motion, second, you're properly recognized.
I appreciate it. Thank you, Mr. Chairman, Committee. What this bill does is
Where is she? Okay, that's fine.
it addresses the eligibility criteria.
And looks like
for
you have an amendment traveling with us as well. It's Amendment 11373. Members, we want to adopt that. You got a
Yes.
motion in a second. All
Yes.
those in favor say aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized.
Yes, sir, Mr. Chairman. Remember, this bill as amended simply removes the unpaid fees and fines as a condition for voting. A person would have to have all of their child support arrearages current for the past 12 months to give them an opportunity to vote. It does not change the bill that passed that Representative Halsey had that really put it in a different statute. None of that changes. Have to pay full restitution, fines and fees. This only addressed the child support part of it.
All right, members, you heard the explanation. Any questions for, Representative Garrett, recognized.
Thank you. Thank you, Mr. Chairman. I just heard your talking points. I want to make sure I'm clear.
Mm-hmm.
You said if their child support arrearages is current for the past 12 months.
Yeah, they have to have demonstrated that over the last 12 months. They
That they're-
have to be current, all the arrearages and current over the last 12 months.
So if their arrearages are more than 12 months in arrears,
No, what I'm saying is they have to have consistently paid over the 12 months, no stop, didn't pay this month, didn't pay that month. They're current for at least for the last 12 months, and then they could petition to be given their rights to vote.
okay, let me make sure. So they have 0 child support arrearages.
Yes.
Period.
Correct.
Not necessarily just 0 for the past 12 months.
Correct.
Because child support obviously should be paid as long as the parties have been separated.
Oh,
And of
yes.
course, they could be separated for a whole lot longer than 1 year. So I want to make sure that we're not saying that if there's 5 years worth of child support arrearages, we're only counting the past 12 months, that they're good to go.
Oh,
That's
no.
not what your bill does.
No.
Okay, that's what I wanted to clarify.
Okay,
Thank
yes,
you.
sir. I misspoke.
Very good. Members, any additional questions? All right, I have Chairman Todd. You're recognized.
Thank you, Mr. Chairman. The question I have is a couple. First, what rights for these sets of crimes, what rights are usually taken from these folks convicted of these crimes?
Representative Camper, you're recognized.
I'm not sure what you're asking.
the list of rights that are given up by these criminals, these serious crimes, what all rights, you're talking about voting rights, but what other rights are taken from them?
I think I'd have to have you defer to legal because I'm sure it's going to be different based on infamous crimes. And, I'm just not sure of the answer. I would not want to go on the record to try to delineate the different privileges that would be revoked. I just don't know the answer to that. Legal may know.
Very good.
Mr. Chair, I would love for legal to tell us that. That's, to me, it's important. We're talking about a civil right here. What other civil rights are removed from these criminals?
Very good, members. Chairman Todd has asked if we could go out of session and hear from legal. Any objection? All right, seeing none. All right, we're out of session. And Ms. Fogarty?
Michelle Fogarty, Legal Services. What her bill is addressing just applies to the right of suffrage. However, the eligibility in this chapter in part lists what is considered the rights of citizenship. And those are listed as the right to serve on a jury, the right of suffrage, the right to hold a public office, the right to execute a fiduciary office, and the right to possess a firearm. But again, the portion that she's amending only applies to the right of suffrage.
Okay. Thank you.
Members, any additional questions? Representative Bolso and then Representative Garrett.
Thank you, Mr. Chairman. I also have a question for legal. Representative Garrett posed a hypothetical question of a previously incarcerated person who might have 5 years of outstanding child arrearages but had been consistently paying for the past 12 months. And I understood that the bill sponsor to say that there was it was the case under this language that a previously incarcerated person would not have prior arrearages for the bill to take effect. And as I read the language, so long as the previously incarcerated person has consistently paid child support for the past 12 months, even if there are other arrearages, that person still receives the right of suffrage. Do I read the bill correctly?
President Kemper? Oh, excuse me. Ms. Fogarty? All right, we'll just stick there.
Michelle Fogarty, Legal Services. The language in the bill is, and this is in regards to a person being eligible to petition for restoration of rights of citizenship. It does not determine it's just whether or not they're eligible to make that petition. The language has been compliant with all child support orders for the previous 12 months, including all orders related to child support arrearages. So the person could have arrearages. They just have to have been compliant for the past 12 months on all orders related to child support payments.
Thank you, Mr. Chairman. Thank you, legal.
Representative Garrett, do you have a follow-up?
Yes, thank you and just so I'm clear, there's not a cleared out child support arrearage for this to be restored. There still can be an arrearage owed beyond that 12 months. I want to make sure that I'm clear on this because that's going to hinge on whether or not I can support the piece of legislation.
Ms. Fogarty?
The person could have arrearages,
Okay.
yes.
Thank you.
Very good. Members, any additional questions for legal? Representative Hardaway, you recognize.
Thank you, Chairman. So if I'm reading it correctly, it's all about the court order. If they're compliant with the latest court order that's designed to address the delinquency, then that is what makes them eligible for this. Is that correct?
Madam
Attorney?
Michelle Fogarty, Legal Services. They have to be compliant with all child support orders for the previous 12 months.
President Hardaway.
And that order could be, the child support order could be a modification of the original order whereby the court has said this is the method, the payment plan by which you will address the arrearages and the ongoing child support.
Ms. Fogarty?
Yes, it says all child support orders, including orders related to child support arrearages.
All right, so just to sum it up, if the courts have said the latest court order says you should be doing something and you've adhered to that order, over the past year, then you would be eligible under this law that we're about to pass.
You would be eligible under this particular subsection of the statute, yes.
Very good. Representative Salinas?
So this would allow them to petition. It doesn't automatically restore. Is that correct? Am I interpreting that correct? Yes, that's correct. Okay, thank you.
Very good. Members, any additional questions for legal? All right, Chairman Dockett, you're recognized.
Thank you, Mr. Chairman. Who would make the determination or the verification of the status if they were current with those orders under this? Would it be the courts, or who would be the one that would make that determination?
I believe they are required to include that documentation of that with their petition. It would be up to the court to verify that. And the district attorney also has the ability to, is also part of this hearing process, and they would have the ability to object or raise questions, as is the attorney general.
Thank you.
Members, any additional questions for Ms. Fogarty? All right, any objection going back into session? Representative Hardaway?
Thank you, Chairman. Before we go back in, can we see if the sponsor has any witnesses?
Any additional questions for legals, members? All right, seeing any objection going back into session? All right, seeing none, we're back in session. All right, Chairman Todd, you recognized.
Thank you for that, sir. And to what legal answered while ago to my question, so there are several rights that are removed from these criminals, and you're only addressing one of those, the voting rights. And I have a little concern about that. Why aren't we including all those rights?
Representative Camper, you recognized.
Well, this is just the area that I was particularly focusing on. I do have someone that I would like to testify, but I wasn't trying to deal with the entire gamut of restoring people's right. I was just concerned about suffrage.
Chairman Todd.
Well, I would argue their Second Amendment right is just as important as their First Amendment and their right to vote. And I would think that that would be something that should be addressed at some point.
All right, members, we're going to take, without objection, we'll take a 1-minute recess. All right, members, thank you. Sorry about that brief delay there. Just one moment there. I think Leader Camper's going to want to recognize Leader Camper. You're recognized.
Thank you, Mr. Chairman and members. I understand there's some unreadiness. I want to talk with a couple of the members to get this resolved. So when the bill comes back before you, I want to roll it for a couple of weeks. That everybody have a clearer understanding of what we're trying to accomplish. So with that, Mr. Chairman, I'd like to roll it till, it's not going to put it on a special calendar or anything like that,
What we can
right?
do, no, I think because we don't have committee next week. So if you roll it for 1 week, that'll give us until two, just roll it for 2 weeks and then that way the clerks will set it on that calendar.
All right. Let's do
And
that.
we'll get you there.
All right, thank you, Mr.
Thank you so
Chairman.
much. All
Thank
right,
you,
without
committee.
objection, roll 2 weeks.
Yeah, mhm.
That's House Bill 687. Okay, members, we have 2 things we're going to have to get finished today. We have a confirmation hearing, and then we've got also a short presentation. So with that, if we could move to item number 12, that's House Joint Resolution 878. And Chair Lady Davis, my mind just went somewhere else. You're properly recognized. I'm so sorry.
Thank you, Mr. Chairman. So I would like to make a move for a positive recommendation for Joshua Walker to be appointed to the Tennessee Claims Commission as the Eastern Grand Division Commissioner. And is Mr. Walker here?
He is, and I should have brought him up. Mr. Walker, if you'd like to come on up here and just have a seat there. Any of those chairs be fine. And as you're introduced, I should have brought you up. Appreciate you being here.
So, committee, Mr. Walker has graduated from the University of Tennessee College of Law, summa cum laude, Order of the Column, ranked second in his 2003 class. He also practiced law for 8 years. He was moved to the Office of General Counsel for the University of Tennessee System, where his primary responsibility was defending the state of Tennessee in claims before the Claims Commission. And so, if we can recognize Mr. Walker and let him introduce himself, I'd appreciate it, Mr. Chair.
Yeah, thank you, Madam Chair. Mr. Walker, thank you for being here. Members, sir, if you'd like to go ahead and make some remarks and just kind of introduce yourself to us, and we'll let members ask any questions they have for you. And without objection, we're going to go out of session and do so.
Thank you, Chairman Farmer. Thank you, Vice Chair Davis, for the introduction. My name is Josh Walker. As she said, I do have to point out that I'm here with my wife, Dana, today. She is a elementary school teacher in Midway down in Roane County. And she was kind enough to come with me and offer her support. Also, after hearing the testimony of the 3 previous people today, I came to the quick realization of how comparatively unimportant what I'm here to do is. So I don't want to trivialize it, but after hearing what those folks had to say, I'm not going to talk very long. You got a description of my legal practice so far. I did spend the last 13 and a half years practicing before the commission. Primarily, that was about 85% of what I did on a daily basis. I'm very thankful for Governor Lee that he gave me the privilege of appointing me to this position. It was effective July 1st, and now I'm here for the confirmation. So I've been performing the job since July 1. And with that, I would hope to be able to answer any questions that any members of the committee might have for me.
Members, we have any questions for Mr. Walker? I know I will say that I've worked with you, sir, in the past in the legal field there. I know you're good at what you do. I know you've got the experience and have the experience to do what you're doing now. And I congratulate Governor Lee on another good suggestion and confirmation and appointment for us to consider. So members, with that, do we have any questions for Mr. Walker? All right, seeing none. All right, without objection, we'll go back into.
Thank you to the
Representative Hardaway, actually. He caught me on the back end there. All right.
Thank you, Chairman. And good afternoon.
Good afternoon.
To you, Mr. Walker. In the HJR, it speaks to your work representing, I believe, UT and employees in federal civil rights actions. Which side of the fence are you on that? Are you defending?
When I was at the university,
individual employees or the school overall? Where?
Well, that would depend on what function I was doing. Claims before the commission are the proper defendant is the state of Tennessee based on something that a state employee has either done or not done. So the defendant is technically the state itself. And if there's a judgment or settlement in those type cases before the commission, that is either against the state or paid by the state, as opposed to the individual employee. The civil rights actions that you just mentioned, I would run into those most frequently when I was at the university, and that would be one of the officers, say on the Knoxville campus or the Chattanooga campus, had a section, a U.S. 1983, or Section 1983 claim filed against him or her, then I would be defending that person individually in federal court as opposed to the Claims Commission.
All right. That's all I had, Mr. Chairman.
Very good. Members, any additional questions? All right. Thank you for being here, Mr. Walker. All right, objection, we're going to go back into session. And we will, excellent work. We have any objection to the question? All right, very good. All right, members, looks like we're voting to send House Joint Resolution along with Mr. Walker to the Finance, Ways and Means Committee. All those in favor, excuse me, we are going to, House Joint Resolution 878. We'll be moving to calendar and rules. All those in favor, vote aye. Opposed, vote no. So remember, voted. Anybody want to change the vote? All right, very good. All right, Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 3 present not voting.
Very good. Congratulations, Mr. Walker. You will be moving on to the Calendar and Rules Committee. Members, House Joint Resolution 878 will be moving to Calendar and Rules. Thank you for being here. All right, members, we have a presentation that we're going to have to go out of session for to take up now. So without objection, we're going out of session. We're going to hear from Arnold Ventures. We've got Miss Jen Doliak, I believe, is here. Jen, are you present? Members, without objection, we'll go out of session. Representative Hardaway, you recognized. What's up?
Thank you, Chairman. Just trying to make sure we don't forget Rep. Hale.
Members, would you all like to hold the pattern now and take up Representative Hill's bill? It should be fairly quick. Representative Hill, members, that's House Bill. Jim, Ms. Doliak, you just stay right there, please. Without objection, we're going to go back into session. And since Representative Hill has been patiently waiting, sir, that is House Bill 1715. You got a motion and a second. Looks like we got House Amendment 12847 traveling with it. So you got a motion and a second on it. Members, are we ready to vote? Any objection to the question on the amendment? Seeing none, all those in favor of adopting House Amendment 12847, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized, sir.
Thank you, Chair and Committee. This bill simply was brought to me by our election administrator. His wife received a jury duty summons for when she had just had a baby. I think it was 2 weeks old or maybe less. And so when I went and filed, he brought this to me. And so this basically just exempts them from while they're breastfeeding and if they have a statement from their physician or a midwife.
We're getting any questions? I have Chair Lady Davis on the list.
Question on the bill.
Question's been called. Any objection to the question? All right, I see objection. There's objection. All those in favor of the question, calling the question, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the question. Members, all those in favor of sending House Bill 1715 as amended to calendar and rules. Madam Clerk, open the board. Members vote aye. Opposed, vote no. Anyone want to change their vote? Every member voted. All right, very good. Madam Clerk, take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations, Representative Hill. House Bill 1715 as amended is moving to calendar and rules. Thank you. All right, members. So now we're back on our presentation. Ms. Doliak, thank you for your patience. So without objection, we'll go out of session to hear from Ms. Doliak. Thank you. Ma'am, if you would, I believe you should have right at 15 minutes. You've got the rest of the committee time.
Okay,
so
great.
You can introduce yourself, tell us a little bit about what you do, what your company does, and we'd be happy to have any questions. We'll use the rest of the community time for you.
Amazing. Thank you.
Thank you.
Thank you all so much. I'm Jennifer Doliak. I am an economist by training. I was an economics professor for many years. Now I lead the criminal justice program at Arnold Ventures, which is a philanthropy based in Texas. And we focus on evidence-based policy. So my interest in this policy space very much comes from the research side, going out and testing what works in the real world, and looking for natural experiments, or even sometimes being able to run actual experiments to test whether our good ideas are working as well as we hope they will. And so the kinds of policies that you all work hard to enact every day are exactly the kinds of innovations in this space that people like me want to go out and see, like, okay, well, did this work, right? Like, what outcomes did we see in the real world as a result? And what can we learn from this that maybe we can take to other states? So I have a new book coming out called The Science of Second Chances, where I talk a lot about this. Happy to talk a little bit about some of the ideas that we've learned from the field, but also just happy to take questions. So one thing that's come out from the evidence over many decades at this point is that if we want to deter crime, the best way to do that is to increase the certainty of getting caught. So increase the swiftness and certainty of consequences. That's the way to achieve behavioral change, rather than focusing on the severity of consequences, right? There might be a reason we want to lock someone up for a long time coming from just wanting retribution and punishment for that reason. But for a public safety standpoint, no one's thinking that far ahead when they're on the margin of committing crime. It's really all about having swift, certain, predictable consequences. And frankly, that's just the opposite of the way we've really built our criminal justice system over the years. Solve rates for crimes across the country are much lower than I think most people realize. And so thinking of innovative ways to be able to change that is top of mind for my team and I. Another area we're thinking a lot about these days is access to mental health care. So we have a lot of really strong evidence that increasing access to mental health care for young men in particular is really helpful for reducing crime and recidivism. And that is easier said than done. Then I think the question then becomes like, what are the levers we can actually pull to make that happen, especially for young men who might not willingly or, eagerly sign up to go to therapy, right? And so I'm really interested in some of these new AI tools. As we hear a lot about the bad news about AI as rabbit holes that can make mental health. But there are also people trying to use AI and design applications that can help basically scale the current mental health workforce that we have that's really limited. And so trying to think about innovations like that we could that could be better than nothing, which is currently what a lot of people have. Let's see. Another thing that we're thinking a lot about related to mental health, but for less severe applications is cognitive behavioral therapy. We have a lot of really strong evidence, usually from randomized controlled trials of programs that engage or use cognitive behavioral therapy, often with some carrot to get young men to engage in the program. So you can get a job, but you also have to come into the CBT program once a week. And cognitive behavioral therapy basically just challenges. It's the sort of thing that could be useful for anyone, and a lot of people engage. There might be people in this room who've engaged in CBT, and it's basically a way to challenge the scripts that are in our heads about the way that interactions will go, and really help everybody just make more careful, deliberate decisions, not trying to push people one way or the other, but helping people understand the consequences of their actions and just think deliberately about trade-offs, which of course, as an economist, I love. But these programs have been found to be really effective at reducing violent crime. And so it's the sort of thing where maybe it might sound to some people in the room like it's too good to be true, but it's been tested in the real world several times in different and again, using some sort of carrot to get people to engage, whether it's a job or a mentoring program, but pair it with CBT, and you see future violent arrests plummet after that. And so we're working really hard to figure out how do we scale those kinds of programs across the country. We're also thinking a lot about corrections and how do we help use jail and prison as an intervention for people who are, while they're incarcerated. The worst case scenario, honestly, is that we use prison as a holding pen. If that's the best we can do, that can do some good, right? You keep people who are an active public safety threat off the street. That keeps communities safer. But gosh, that's a lot of money to spend if that's all we're doing. And it would be much better if we're able to use that as an intervention point to path so that they're in a better place when they come out than when they came in. And the reality is we don't know really whether most of our programs in prison are working, if they're effective at anything. We just haven't tested them. I'm confident we could do better than we're doing right now if we actually got serious about, let's go implement these programs in a way that we can learn over time what's the impact that they're having on people, and then try new things and see if they work better than what we're doing right now. And so, we do a lot on the research side to try to run those kinds of studies. But we're also talking to a lot of corrections officers who tell us about the real crises we're seeing in our corrections facilities across the country and the understaffing that leads to violence, which leads to even more understaffing because no one wants to work in those conditions. And we were having lots of conversations where we see corrections officers and families of the incarcerated come together and say, our corrections facilities are really in crisis right now, and something's got to give. And, the upside to a crisis like that is people are willing to try crazy ideas that they might not have been willing to try previously. So just as an example, we're funding some randomized trials of basically Scandinavian prison units in places like South Carolina and Pennsylvania and Missouri, the types of units that are more open, inmates can cook for themselves. There's a more collegial relationship between the inmates and the guards. And the idea is it gives people more responsibility, and that responsibility begets rehabilitation. So we're studying to see what the impact on both violence while people are incarcerated is, but also on recidivism. The hope is that this rehabilitates. We should see better recidivism rates. But the most striking thing to come out of a lot of those experiments, even while they're still ongoing, is how much the guards or the corrections officers love working in these units. And so Pennsylvania, for instance, has decided they're going to expand this program to other units because of demand from the corrections officer side. They want to work in units like this. This makes the job more meaningful. And in a context where the workforce shortage is top of mind, it's one of the biggest challenges that the corrections facilities have, that's a really big signal to them. And so it's just been interesting to see the willingness to try new things, and then maybe some surprising results that come out of them that we wouldn't have thought of earlier. Happy to pause and take questions. I'm happy to talk about whatever is on your mind. This is my absolute favorite topic. So,
And thank you for that. And I have Representative Bolso, sir, or Chairman Bolso, you recognize.
Thank you, Mr. Chairman, and thank you, Dr. Doliak, for being here. You said something that struck me as counterintuitive, which is that our clearance rates are lower now in criminal justice than they have been previously. Given all of these scientific methods we have to solve crimes, how is it possible that our clearance rates today are lower than they have been in the past?
this is in some ways $1 million question. It feels like technology has gotten better and better. And yet we've seen clearance rates fall over the past many decades. I think there are two answers to this. One is we really haven't focused on clearance rates as being one of the main metrics that we're focusing on, right? A lot of departments focus on crime rates, as they should, and arrest rates, and seeing like as a signal of effort from officers going out and seeing like, are you making arrests every day? And I think for whatever reason, we've lost focus or haven't ever really focused on how many crimes have we solved, how many crimes have we cleared as being one of the metrics that we want a police department to really be focusing on. And so lack of attention means, you know, it's not something that is driving behavior. I think the other part of the answer, my hunch, is that a lot of the technology that does make it easier to solve crime also makes it easier to show that this person you might have arrested before is not the person who did it, right? And so it might have been easier to make an arrest and clear a case before, but that doesn't mean you got the right guy. And now it's easier to tell that this isn't the right person, but unfortunately, we're not finding the right person.
And based on your research, Dr. Dolak, are there any specific measures that you can recommend to a legislative body like us to improve those clearance rates so that we have a greater likelihood of a conviction of a crime?
Yeah, so clearance rate is basically just the number of arrests you're making divided by how many reported crimes there are. So we have I think we've got model legislation that Arnold Ventures has on clearance rates that we can be happy to send to you. But in general, I think just tracking how many arrests for particular crimes were made relative to how many reported crimes were actually committed. That's what you want to be tracking is just how many crimes were cleared. And ideally, I mean, that's just using police data. Ideally, you're able to actually link the record prosecutor and the court data to see how many convictions you get. That would be, the ideal. And I recognize that linking all those records is another step that takes a little longer. But yeah, happy to send a model bill.
Thank you, Mr. Chairman. Thank you, Dr. Doliak.
Very good. And I have Representative Hardaway. Sir, you recognize. We got about 4 more minutes, members. So if we want to be cognizant just with the time for other members, I got two other members on a list. So,
all right, thank you, Chairman, and good afternoon, ma'am. On the effectiveness of the prison programs, what's the difficulty in figuring out who's contributing what to the ultimate outcome?
Yeah. So the really hard part here is that the ideal scenario you want, or what someone like me would want, is an experiment, have a randomized trial, right? You have a program and you randomly assign some people to the program and not others. We can't do that in prison for a bunch of different reasons. They're worried about safety. But the way that people are enrolling in programs now, it's very much a personal choice, or they're being assigned or like really pushed based on their personal needs. So maybe I'm really motivated to change my life, and so I sign up for all these different jobs programs. Well, it might, maybe the jobs programs helped, maybe they didn't. But when you compare someone who was really motivated to sign up for lots of programs with someone who wasn't motivated to sign up with all those programs, maybe it's not surprising that the motivated person does better than the unmotivated person. And so what you're seeing is differences in motivation, or differences in risk scores or something that determine whether someone got onto the program to begin with.
All right, then, Mr. Chairman, deferring to my colleagues, I'll just keep that one question and get hold of you outside.
All right, great.
Thank you, sir. Appreciate you. Representative Johnson, you're recognized.
Thank you, Mr. Chairman. In regards to clearing, I'm just curious, is there a particular area of or type of crime that we're not clearing? Because I just know in Knoxville, we're doing, like, we've really stepped it up on clearing homicides. And so
Amazing.
I'm
Yeah.
curious if it's everything across the board or if there's something in particular more than others.
Yeah, different cities have different problems. I think most of the attention tends to go to homicide for good reason. It's the most serious offense. I think the closest offense to it that we often lose sight of are non-fatal shootings. That's, just kind of luck determine whether the person died or not. And then honestly, a lot of lower level offenses where you see people churning through the system, probably because they recognize that it's very unlikely they'll get caught. So anything like burglary, theft, motor vehicle theft, those types of clearance rates are 10, 15%. And my typical joke is that we should all be stealing cars, right? There's just, it's very unlikely you'll get caught.
Yeah, and that's another good thing in Knoxville is we're seeing a drop in non-fatal homicide. I mean,
that's great.
non-fatal gun violence too. So.
I would love to talk about what you're doing in Knoxville.
All right, very good. Members, yeah, you're recognized. Absolutely. Representative Towns.
Mr. Chairman, thank you very much. Couple of comments. Did you say you were an attorney?
I'm an economist.
Okay, economist. Okay. Show me how to multiply my money. Okay. First is you made another comment as it relates to how you have people in this area with just a large block of time and nothing is really happening to edify them or improve them. One of the things I tried to do some time ago, which I think would be a model around the country, if they were allowed and or encouraged to go and attend school while they're there, teach them the GEDs or whatever else they can get so they can have something that will level up after they leave, because you got undivided attention for sure.
Yeah.
And the lock is going to turn twice. So you're going to come out at some point.
Yeah.
And as an incentive, maybe whatever crimes time could be reduced a little bit as an encouragement that they go to school.
Yeah.
I think they ought to go to school.
Yeah. So that makes total sense to me. We don't have great evidence on the impact of education programs specifically. There's a little bit coming out saying, this is just, again, a place where we should know much more than we do about individual prison programs. On earned time credits, we do have really strong evidence that giving people, and this is again because most of this group is not thinking very far ahead. And so, it seems like you're going to be in prison for a while. Eventually, you're going to get out. You've got the incentive to invest in yourself now. But moving up the consequences is really helpful. And so if you're able to provide an incentive to engage in rehabilitative programming, and that will shorten your sentence, you'll get out earlier, that's a carrot that really works, that incentivizes that participation. And then we see that then reduces recidivism afterwards. So having that opportunity for early release based on programs. Yep.
Well, I appreciate that, but I don't think it's either or. I think it's both and, because once they get out, they got to immediately find something else productive to do.
Yep.
Idle mind is the devil's workshop, as the old folk taught us back in the day. They got to have the equipment, and then they got to have something that they can do to make money, make a living. Because if not, at least two are coming back sooner than they are coming back, period. Thank you for your work.
Yeah, completely agree. And I think the hard part is, I'm sure my hunch is everyone in the room would agree with that. I think the hard part is figuring out what can we do to intervene that actually helps people. be in a situation where they'll be on a better path when they get out. And I'm excited to just see if you've got ideas, I'd love to go out and
That's
test
the
them.
reason we get paid the big money.
Yeah,
We have to figure it out.
exactly. Yeah.
And
Yeah.
with that, we are out of time. We
All right.
appreciate you being here today. And I'm
Thank you
sure
very
you would
much.
be happy to make yourself available to anyone if they had any additional questions. Once again, thank you for being here. Members, without objection, we'll go back into session. And with that said, I'll entertain a motion to adjourn. I've heard it. Excuse me. We are going to roll without objection all remaining bills to next calendar. All right. Without objection, we're next calendar and we're adjourned. All right.